Just so you know, we've emptied the room and we're rescuing, so. Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, everyone. This is S-1-SC-39381, State Exrel Balderas versus Gilead Science, Inc. Can I have entries of appearance, please?
Good morning. My name is Michelle Hernandez. I'm with the Model Spraying Law Firm. I'm here on behalf of Gilead with my co-counsel, Jay Lefkowitz and Kirkland Nels. We'll be making our argument.
May it please the court, Andrew Schultz with the Rody Law Firm on behalf of TIVA. My co-counsel, Brian Burgess, will be making the argument.
Good morning, Your Honors. David Stanek with Cantor and Whiteley on behalf of the state. With me today from the Attorney General's office is Ms. Alethea Allen.
Thank you. It appears that the time has been split between petitioners. 15 minutes for Gilead, 10 for TIVA, and then 5 minutes reserved for rebuttal. Is that accurate?
Correct.
All right. With that, Mr. Lefkowitz, you can take it away.
Madam Chief Justice, and may it please the court. When the Court of Appeals decided Sproul over a decade ago, courts across the country were divided as to whether the stream of commerce theory was a sufficient basis on its own for the assertion of specific personal jurisdiction, or if something more, namely purposeful availment of the forum, was required. In the decades since then, the United States Supreme Court in Ford and BMS, as recognized by this court in its 2021 decision in Chavez, recognized that the question is no longer about stream of commerce. Now the Supreme Court has made absolutely clear that there is a new test, and it is a two-part test. One, the plaintiff has to show that the defendant purposefully availed itself of the forum state, and two, that the plaintiff's claims arise out of or relate to that forum-specific conduct. In other words, even purposeful availment is no longer sufficient.
I point to record proper, and I know, I'll tell you what I'm looking at, because I know it's a little unfair given how big this record is. 935, 934, it's the posting for a therapeutic specialist. And I will represent to you that it talks, well, it lists it specifically in Albuquerque. It refers to hepatitis C virus HCV. I assume it is the drug at issue in this case. And it talks specifically about promoting both the product and the market in New Mexico. So don't we get there?
Your Honor, thank you. That we actually don't. Again, that is a LinkedIn job posting which was posted 7 months after the plaintiffs filed their cause of action. It is not for the HIV drugs at issue in this case. We know, and in fact, the Court of Appeals just last month in the Grano case said there is no personal jurisdiction over an out-of-state company that even has a direct referral relationship with a New Mexico hospital in a different type of medicine, in bariatric surgery as opposed to aortic surgery. The related to test, as Justice Kagan said in the Ford decision, is very clear and it has meaningful limits. In addition, we make very clear, and it is in fact unrebutted at RP 571, that none of Gilead's research, development, commercialization, or marketing functions for HIV treatments is located in New Mexico. Now, if, for example, there had been a lawsuit over hepatitis drugs in New Mexico, then if in fact there had been evidence of commercial sales by Gilead or commercial efforts to sell, again, it would have to be 7 months earlier, because we know that things that happen after the filing of the complaint also don't demonstrate the requisite test at the time.
Targeting our attention on Ford, Justice Kagan talks about the affiliation, but really describes it as something that is very minimal, that affiliation. It's not kind of the international shoot over contacts anymore, and describes it as the underlying controversy as an activity or an occurrence that takes place in the forum. So we're not even, we can eliminate occurrence and just look at the plain meaning of the word activity.
Well,
As the definition of affiliation with the state, that related to language. And here, what about the engaging in the system that's described, at least in the briefing, where patients in New Mexico were compensated, offset for the cost of the drug, the very drug at issue here?
So two things, two-part answer, Your Honor. First of all, in Ford, what the Supreme Court, Justice Kagan's opinion makes clear is, first of all, and I'm quoting, Ford had advertised, sold, and serviced those same two car models in both states for many years. In other words, Ford systematically served the market.
I don't disagree that the facts of Ford are different than they are here. But the legal principle within Ford starts to look more like, you know, if we want to use language that's out there, it's like, instead of stream of commerce plus, it's stream of commerce but a little.
It's actually not stream of commerce.
I know, but that's what it feels like when she's talking about arising out of or related to, and then just says, well, it's kind of any old activity will suffice.
So, but any old activity doesn't suffice under the Supreme Court's test. In fact, we know that because Ford and Bristol-Myers both unequivocally, purposely availed themselves of their markets. Bristol-Myers by having 5 research facilities, a lobbying office in Sacramento, hundreds of employees in the state. Ford had 60 some odd dealerships in these 2 states. They were advertising on billboards by every means imaginable. If all that was required was having a national presence and having your product serve that market, ultimately, Ford and BMS would have been one-sentence decisions. And to your specific question about the payment assistance, the payment assistance is not targeted in any way at New Mexico. It is on Gilead's website. It's like Amazon saying—
Was it used in New Mexico?
What?
Was it used in New Mexico?
It was not used by the Attorney General. In fact, the Attorney General was excluded.
Was there any payment assistance program targeted?
There was payment, there may well have been payment assistance for the drugs, but not connected to the lawsuit here, because the lawsuit, Your Honor, relates to the state's alleged overpayment. And the state was expressly excluded from that payment assistance program. And therefore, it is not related to the litigation here. There's no question that the payment assistance was offered. Now, I would suggest, Your Honor, that a payment assistance program that's offered nationally is not targeted at New Mexico. It's like if Amazon says the day after Thanksgiving, everybody gets a $10 discount off their next purchase. People from all 50 states can avail themselves of that, and that's not purposeful direction targeting New Mexico. This isn't either. But in addition to this not targeting New Mexico, it would be different, for example, if we had posters on the sidewalk in Albuquerque or targeted ads in New Mexico saying anyone who goes to the local CVS gets a discount for a Gilead drug. That would be both targeting, although it still wouldn't be related to this lawsuit because the New Mexico lawsuit is based on alleged overpayments for the Medicaid program, and that is simply not related to the conduct in the state. And what this court recognized in Chavez, and then on remand, it's very interesting. Chavez on remand followed this court's direction and said, yes, it is sufficient. Why? Because the tire company there has channels of communication directly engaging with citizens of New Mexico. We don't have even an allegation of that here. We also, in Chavez on remand, had accounts related to advertising and marketing directly in New Mexico. There's no such allegation here. This is serving a nationwide audience. And if serving a
So
nationwide,
you can avoid personal jurisdiction in the state by calling it a nationwide, but still offer the reduction in price in the state, and you're saying you're not availing yourself?
not, Your Honor, if, first of all, I agree. I don't believe that that is purposeful availment if you have a national program, because if that were the case, then every company that has any kind of
Okay.
national
Let's take them
discount-
together. Let's take them together. You have a national program,
Correct?
and then at the state level, you have a particular program that creates an incentive to purchase the drug to a patient in New Mexico. That might be hurt if they can't pay the generic price.
So, Your Honor, two things. One, this is not a targeted program at New Mexico. This is just the national program. If it were targeted, if it were a New Mexico specific program, if it said, for example, anyone in the country, anyone in the universe can get a $10 discount on Gilead drugs, but New Mexico citizens can get a $20 discount, that would be targeted in New Mexico. But even if you found purposeful availment, what Ford and Bristol-Myers tell us is you still need to have the conduct within the state related to the claim. Now, what is this claim? The claim here is that New Mexico says we paid more for the drugs that were reimbursed through Medicaid. But Medicaid is not eligible for that discount program anyway. So I think it actually fails both the purposeful availment test and the related to test. And the problem with stream of commerce is stream of commerce doesn't require that you satisfy either prong of that test. In stream of commerce, all you do is you manufacture a product, whether it's a drug or an automobile or roofing for a house, and it ends up being used and allegedly injures consumers in the jurisdiction. If that were sufficient, the Supreme Court would not have articulated its very clear two-part test, because all of these cases would find personal jurisdiction. And we've actually progressed even beyond Sproul, because in Sproul, the debate was, is purposeful availment required, or is it just stream of commerce? Now the Supreme Court says even purposeful availment is not sufficient. Bristol-Myers clearly purposefully availed itself of the California market far more than Gilead. It had 5 research laboratories. It had a lobbying office to lobby the California government. It had 160 employees. It sold $900 million, but the claims in that case weren't related to that conduct. And so I think, Your Honor, look, the trial judge here.
Well, wasn't Bristol-Myers also that the plaintiffs had no affiliation with the state?
That's
the primary distinguishing factor in Bristol-Myers.
It is, but the reason the court focused on that, and it made it clear in the opinion, is because the fact that the plaintiffs weren't in the state meant that the plaintiff's conduct, the plaintiff's claim didn't relate to that in-state conduct. And that's why Ford then takes it another step and actually goes and says, no question, there's a veritable truckload of contacts with the state, all of this advertising, all this repair. And then it says, and the plaintiffs bought the very vehicles that they're out there making a market in. So if we had a clinic down the street here, an HIV clinic, and we were selling our drugs in New Mexico, in Santa Fe, in Albuquerque, that would be a very different story. We don't sell, and you know, it's interesting, Justice then Judge Villa, in the Sproul case, he found personal jurisdiction not applying Judge Vanzie's test. He said, I'm going to look at purposeful availment. But what did he look at? He looked at whether there were regularly established channels of communication, which we don't have. He also looked at whether or not they sold through an agent who is really just part of the company. It's just an agency relationship. Here, Gilead sells its drugs to billion-dollar third-party companies who then make independent decisions about where to sell and what to do. If you find jurisdiction here, you are essentially saying stream of commerce is sufficient. We don't have to do the test for purposeful availment and related to.
Are you conceding that if we identify stream of commerce, that it applies in antitrust cases as opposed to strict liability, and if not, why?
I'm not conceding that. I am conceding that there is a split of authority around the country on that. I think probably the best answer, the answer given by then Judge Barrett, now Chief Justice Barrett in the Seventh Circuit case we cite, is that non-products cases are different, because at least in a products case, and this was articulated in the dicta from Volkswagen, which eventually became stream of commerce in some states, at least in that situation, it's the product itself that's directly causing the harm, as opposed to the actions of third parties out of state. But I recognize that if you find stream of commerce is the guiding principle here, as opposed to the Ford and BMS test, you may well find that stream of commerce isn't limited just to product liability. I would suggest that it would be the wrong answer, but that's a closer question in court split. I just don't think stream of commerce has any legs at this point anymore. And I would just close, Your Honor, by saying, we know that the trial judge didn't look at the proper test because the trial judge thought Sproul applied. And so even when she makes a vague passing reference to findings, at most she could have been looking at purposeful availment. We know she couldn't have looked at related to, because that didn't come into the doctrine yet. And so I believe this court can do one of two things. This court could simply look at the record de novo, and I'll save it for rebuttal. Thank you, Your Honor.
Good morning, Your Honor. Brian Burgess for Teva Pharmaceuticals. We agree with Gilead's articulation of the legal principles in this case and how they apply to the facts here. I'm happy to answer any questions. I'd like to focus on the issues specific to Teva. Plaintiff has tried to avoid the certified question here by downplaying the Sproul stream of commerce test that it relied on exclusively below, and instead pivoting to what it calls a traditional specific jurisdiction. But that pivot cannot work for Teva. The district court did not make any findings about traditional specific jurisdiction factors or contacts, and none exist. Teva is being sued solely on the basis of settlements that it entered out of state to resolve out of state patent litigation. It's not implicated in the other legal theories the plaintiffs assert involving, for example, the joint venture agreement between Gilead and Bristol Myers, or the allegations that Gilead tried to shift the market between.
How is it not related to that? I mean, the argument is you entered into a sweetheart settlement to delay the implementation of a generic, which limited the choice of a consumer injured in New Mexico. How is that not related, at least in the context of the antitrust?
Well, we don't think they can be related, for example, to the and we think the allegations are insufficient on their own.
Sure,
terms,
I understand that. I understand that has standard objection to the claim.
Sure.
But we're at the jurisdiction stage.
No, I understand that. But in terms of context about allegations that Gilead is trying to shift the market from the TDF generic products to the TAF, which is what a lot of the allegations about conferences or targeting doctors, that can't involve Teva. Teva was competing with respect to the TDF generic products. So the argument about trying to shift from TDF to TAF is directly contrary to Teva's interests. So I don't see how any of those contacts could potentially be.
You can argue that to the jury. We're talking about jurisdiction.
Well, no, but I mean, but that's a conspiracy theory of jurisdiction that the district court did not rely on, that opposing counsel has acknowledged is not implicated in this case. They are trying to rely entirely on traditional specific jurisdiction as to Teva.
But it seems your argument is because this agreement, and again, assuming it was an illicit agreement to delay the generic, where that's going to be contested, that because that was done in a different state, it still impacted consumers in New Mexico, that there's no personal jurisdiction.
Well, no, our argument is that the alleged impact on the state is not sufficient under Supreme Court precedent, that the relevant inquiry is the defendant's contacts with the forum, not simply the plaintiff's where it's experiencing the harm. That's articulated in Walden, among other cases. And so that can't be itself sufficient. And so the question is, what other contacts does Teva have with the forum? What has it been doing to avail itself of the market? And I would submit that just none exist.
If Teva came back and had a large market share in the generic world 5 years later because of this contested alleged agreement, at that point, what they have?
No, again, because we're not availing ourselves of the New Mexico market. The facts are unrebutted that we sell our products exclusively outside of the state to third-party wholesalers who are not acting as Teva's agents distributing the products in the state. They take title and they make their own decisions about where and at what price to sell the product. So that is the actions of a third party availing itself of the
So can
state,
any
not Teva.
company shield themselves by using wholesalers? Shield themselves from jurisdiction by use of wholesalers?
Well, there could well be other facts if, for example, we were advertising in the state or doing other things to cultivate the market, even though we were selling through wholesalers, that would be a different case. But there are no allegations of that. The unrebutted sworn testimony is that we do not do any advertising in the state, that we do not have any individuals who are engaged with respect to the HIV products and making sales in the state.
So is your client being sued because they were in the room?
We're being sued because we entered a settlement. We don't disagree with the proposition that we could be sued on the basis of that. As indicated in the brief, we are a defendant in litigation in California where Teva has not contested personal jurisdiction. The point is that we cannot be sued in New Mexico for an out-of-state patent settlement, resolving out-of-state patent litigation, where we have done nothing to avail ourselves of the forum. And certainly, I think it's telling that plaintiffs in their brief have tried to move away from the Sproul stream of commerce test to rely on what they call a traditional test, but none of the factors that they try to attribute to Teva hold up. They argue, for example, that we have an extensive sales force in the state, but when you actually look at what they're citing, there's one LinkedIn post of a former Teva salesperson who it's undisputed was not involved in selling the Teva HIV products, was working exclusively on other branded products. And then there's a job posting for someone to be selling cancer products that are, again, have nothing to do with this case. So there are just no contacts that Teva has in the forum that have any relation to New Mexico and to the allegations being put forward. In briefing below, they relied in their specific jurisdiction argument, they relied exclusively on the Sproul stream of commerce test. And as Mr. Lefkowitz indicated, we just don't think that test is consistent with current jurisprudence and subsequent decisions from the U.S. Supreme Court, as well as this court in Chavez. And they have no ability to identify any other contacts that Teva has that connect it to this forum and to this lawsuit. When I mentioned the way in which they mischaracterized the record about sales representatives, they also argue that Teva is engaged in research that's relevant and that they can try to rely on those contacts. But that also doesn't hold up when you look at what they're citing. It's research contributions to researchers at New Mexico by non-defendant affiliates of Teva for research that has nothing to do with HIV products. It involved neurology research and multiple sclerosis. And the Supreme Court in the Bristol-Myers case specifically indicated that such research on other products has no relevance, not that it wasn't even sufficient, but just has no relevance to the specific jurisdiction inquiry. And I do think, Justice Bacon, you were asking about the Ford decision and the scope of relation. I don't think that decision can be read to undermine what the court held in Bristol-Myers, where it wasn't just about the fact that the plaintiff wasn't connected to the forum. Note that the court also specifically rejected the California Supreme Court's sliding scale test, which was to suggest if you had more contacts in the state, you could have a more diluted sort of connection. And the court said that that's not correct. So I don't think the Ford decision a couple years later can be understood to undo that holding. Rather, the court was specifically rejecting a but-for causation standard, recognizing that relation could be broader than but-for causation, but nonetheless imposes real limits on the scope of jurisdiction. And that's why I don't think it was an incidental fact that the court was commenting on that there was advertising and servicing in the market of the particular models. It wasn't just that Ford, did business in the state and had some unrelated contacts. And so that is sufficient because under a broad reading of relation in specific jurisdiction.
Could a car dealership have a neutral national distributor makes independent decisions and avoid personal jurisdiction in New Mexico? Car national dealership decided to sell Ford Focus that product defect, could they avoid it that way?
I mean, I think there would be consequences if they really tried to not avail themselves of the forum, if they really didn't want to engage in advertising in the forum with respect to the product or servicing the product in the forum and really giving distributors total unfettered discretion. If they did all those things, but I think that would be unlikely for them to do it. The generic drug industry operates differently, as the amicus brief from the Association of Accessible Medicine.
It does do that.
Well, because the priority is that, and what we're good at is manufacturing and delivering the drugs, and other distributors are the ones that have the expertise to distribute those through the country. So that's what we do to be able to deliver drugs at the lowest cost possible. If we're not engaged in direct advertising in the way that Ford is, and that is the kind of availment you have of the forum. The only connection that is attributed to us in the forum is the stream of commerce from sales by third parties.
Because you
that
do
we
have a
don't control.
nationwide plan to distribute the drug. I mean, that's the only way you make
Well, we have
lots of money off of generic drugs or branded drugs for that matter.
we have a plan to sell to wholesalers who
Because
themselves
you
have
want-
nationwide footprints. I mean, we don't disagree with that.
You're not going to sell to a wholesaler who says, well, I'm going to sell this drug in Bernalillo County, New Mexico.
Well, we're going to sell to wholesalers who take the most of our product and, pay the prices that we want for it. We're not interested in the particulars of what they do. I don't dispute the idea that we are selling to wholesalers with big footprints that distribute nationwide, and that is foreseeable.
Is it a shock that these products ended up in?
It is not a shock. It is not a surprise, but the Supreme Court has made clear over and over again that foreseeability alone is not a sufficient basis to establish personal jurisdiction.
So I have a question. If the agreement that happened, which was not in this state, and the sale to this third-party distributor that's pretty much probably sold these drugs everywhere, if that's all you're saying the contact is, then and we said that's enough, couldn't you all be sued in all 50 states?
I absolutely agree with that. If that were the test, it would lead to nationwide jurisdiction, which we don't think is consistent with Supreme Court precedent. If the court has no further questions, we urge you to concur.
Good morning, Your Honors. I'd like to start briefly with the standard of review in this case, because both today and in their briefs, Your Honor, I heard no mention at all of the appropriate standard of review and what the district court actually did in the matter below. The district court below made findings of fact, and under tertio, that means a clearly erroneous standard here should apply. Gilead's counsel tried to call it a short shrift statement. The court said below, the district court, the court is going to deny the motion to dismiss, finding there are specific contacts with the action, promoting the conferences, targeting healthcare providers. It made the findings below, and therefore the clearly erroneous standard should apply. Further, in reading all of the defendant's briefs, Your Honors, they intend to impose a standard that's even higher at the motion to dismiss stage on jurisdiction than anyone would have at the summary judgment standard later in the case. Under Santa Fe and a number of other cases, the summary judgment standard and inferences in our favor are appropriate, especially when there was no evidentiary hearing, as the courts below made clear. There was no evidentiary hearing in this matter. We did not have the opportunity to cross-examine their in-house legal counsel's 2-page affidavits. We did not have the opportunity to conduct a discovery. We did not have the opportunity to present witnesses and other evidence other than what we were able to submit with the record to the district court. Their statements in their brief that we're entitled to no inferences in our favor at this stage is completely contrary both to the clearly erroneous standard and the fact that the trial court specifically said she is finding specific contacts to this action, as well as with the inferences that should be in our favor, which is the traditional summary judgment standard. Otherwise, what they're saying, Your Honors, is that simply by having in-house counsel, who are not the business folks, submit a couple-page affidavit saying that we deliver the chattel out of state, that's enough, and then we cannot present evidence, we cannot cross-examine their witnesses, we cannot get other discovery.
Are you asking us to remand so that there can be an evidentiary hearing? I mean, there were affidavits submitted. You had the opportunity to rebut them. What are you asking? with all of this talk about the fact that it wasn't a summary judgment motion? Are you wanting us to remand so that that can happen, or where are you going with this?
Simply saying, Your Honor, that given the state of the record here, the standard on the review of the district court's decision should be clearly erroneous, and that we had to make a prima facie showing with inferences in our favor under the summary judgment standard, which the trial court said was the standard she was applying, and she found that we met that standard. So under that standard, the ruling below should be upheld. I heard a lot of discussion as well, Your Honor, about Sproul. No one's running away from Sproul. They say, oh, we cited Sproul in our the briefing below. Of course we did. Sproul is binding New Mexico Court of Appeals precedent. It's been consistently applied by the Court of Appeals for 10 years. There is no schism. There is no fracture. In fact, the Court of Appeals applied it just a few months ago in Chavez 2 on the remand from Your Honors in that case involving the general jurisdiction question. They considered the specific jurisdiction question under Sproul and applied it, and again, had no trouble finding specific personal jurisdiction existed over the tire manufacturers in the Chavez and consolidated Chavez cases. Among the contacts they also noted were the operation of a website nationwide, much like both defendants have, offering saying, go to these pharmacies, or if you need copay assistance, go ahead. For these specific drugs, we'll give it to you. Those are activities, as Justice Bacon said, focusing on activities from the Ford case. Those are activities certainly showing purposeful availment. They're telling New Mexico consumers, you can buy our drugs. You should buy our drugs. And if you can't afford it, we'll help you out and give you some money. And then what happens? Once those folks are on Medicare, or Medicaid, the state then picks that up and has to keep paying for that and have to reimburse it at super competitive prices that the antitrust and consumer fraud defendants were charging for their drugs.
I need you to spend some time really convincing me that the conduct of Gilead and especially Teva are tethered in some way to the claims in New Mexico. It's still a little mushy.
With this particular drug, if I could add.
Yeah, of
Yeah.
course, with this particular drug.
No, I understand, Your Honor. And I'll state too at the outset that at the district court level, we were arguing for specific general and conspiracy jurisdiction over the defendants. So the fact that certain contacts may bear more on one flavor of jurisdiction than the other, that was pertinent at the time. We raised all that in the briefing. We raised that before the district court. The only issue on this appeal is specific jurisdiction. So I just preface that in saying we had to address a lot of the issues for all flavors of jurisdiction.
But I need you to focus on very specifically specific jurisdiction and what that looks like, and parsing out because to me there are real differences between even what's alleged in the briefing related to Gilead and Teva.
Absolutely, Your Honor. I'm happy to do that. And with Gilead, we allege and we put into the record and put forth the facts showing a number of contacts related to the HIV drugs at issue. Part of the allegations here are that defendants fraudulently, because remember, this is not just an antitrust case. We have a New Mexico unfair trade practices claim as well. But remember the part that they fraudulently induced switching from cheaper, equally efficacious drugs to their more expensive branded price-fixed products. How did they do that? That was based on their, as we alleged, ginning up the research and the trials and promoting it to the healthcare providers, the ones who write the prescriptions for the drugs, and saying, you should do that. Our drugs are branded drugs. They work better than these other older drugs. You should pay more money, state or consumer or what have you, for our newer drugs. Right? So what did they do? The clinical trials for Gilead's drugs partly occurred here in New Mexico.
Where in the record is that supported for this particular drug?
It's in the clinical trial materials that we cite and the studies that show that Southwest Care in New Mexico, both the Albuquerque and Santa Fe sites here, were part of this, and that part of the New Mexico researchers and scientists who were overseeing that, Dr. Gallant and Dr. Hawkins. I believe Dr. Hawkins initially, and then Dr. Gallant became the director. Both of them were leading the studies of Gilead's drugs, which were in part being studied here in New Mexico. Those doctors from New Mexico wrote articles sponsored by Gilead that said that these Gilead products, these very Gilead products, are more efficacious than other drugs. Payers, not just the world at large, payers, third-party payers like the state, you should switch to these drugs in these articles. Those were written by New Mexico providers here to encourage the switching to what we allege are the price-fixed drugs. We have in the record as well, we can find the record citation, I apologize if we need it, Your Honors. But they also, those same New Mexico healthcare provider scientists, Dr. Gallant and Dr. Hawkins, they were part of speaker engagements, conferences that occurred here, and some occurred elsewhere, but some occurred here in New Mexico, and they were specifically about HIV treatment medication, and in the record it says crystal clear, these are about HIV treatments. They were sponsoring, and what do they do at those sponsored symposia? They're telling other providers, hey, you should prescribe Gilead's drugs because they work better. And our allegations are they don't work better. They were doing that as part of a scheme because they had the super competitive price-fixed prices for these drugs. In addition, Your Honors, some of you noted Gilead's contacts with the state on offering payment assistance to New Mexico consumers. We have in the record that Gilead directed patients, the people with HIV, to go to these to use these drugs. Yes, is it a website available to others? Yes, but for New Mexico consumers in the state, you go onto that website.
But how does that lead to damage or injury how does that tether to the Attorney General's claim, given that the state was exempted from that?
They are attempting to say there must be a causal link between the specific contact, the payment assistance program, and the actual damage to the state.
Isn't that what Ford stands for?
That's exactly what Ford rejected, that there need not be a causal link between the contacts that's alleged, right? Because in Ford, remember, it was aftermarket sales of those cars. The stream of commerce ended with a sale to some other customer somewhere else, and then they sold later the car somewhere else.
Well, then again, Kagan turns to, so you're asserting that that's enough of an affiliation.
Yes, we are, Your Honor. And I'd say further that, remember, this Attorney General is bringing these claims. It's for the state's own claims, but those are payments, reimbursements made on behalf of consumers. There would be no payments if New Mexico consumers were not prescribed these drugs by New Mexico healthcare providers. And once they start and are enticed by copay assistance, we'll start you on these drugs, Mr.
Is that copay assistance through these defendants, or is it through this third-party distributor?
Our understanding, it's from the defendants themselves. It's not just the wholesalers, the distributors. These are Gilead and Teva directly saying, you can go to their website today.
Here's a coupon.
Yes, or say, you're a New Mexico resident. I'm going to type in my address at this courthouse. Here are the 3 closest pharmacies where we, Gilead, are telling you, New Mexico consumers, where you can go to buy our drugs. They're purposely, that is purposeful availment if we have to get that far, Your Honor. It's certainly activity within the state related to the promotion of these price-fixed drugs. Once you have doctors prescribing the drugs, once you have consumers, for lack of a better word, hooked on them, the state is going to continue to reimburse for them because that's what it has to do under the Medicaid program.
So is that Gilead's website, not Teva?
Both of them. I was speaking specifically as the Gilead's right now, Your Honor, but we also have in the record, Teva also directing folks on which distributors use their drugs and where you can buy them.
But there's not a coupon, it's just the information.
They also offer assistance programs.
Now, does it apply to Medicaid patients?
It would, Medicaid, or if you're on Medicaid, you would not technically, I believe, be eligible for that specific reimbursement. But again, the activity of we're encouraging this susceptible population to use this drug, and we'll say we'll give you a few bucks so you can start on it when your New Mexico doctor prescribes it to you, and then eventually you'll probably end up on Medicaid, and then the state has to keep, by law, continue to pay for those drugs that are prescribed.
So you talked about the clinical trials.
Yes.
And the doctors Gallant and Hawkins.
Yes,
And I just want to make sure I'm understanding, those are both related to defendant or to Gilead, not to,
yes,
okay.
that's right. And then and thank you, Your Honor. And
I just want to, so what are the connections to the other?
And then back to Teva, in addition to their offering New Mexico consumers assistance with payments for the drugs, they also they're also listed as a sponsor of speakers, a funder, in one of the New Mexico, I referenced earlier, a symposium that occurred in New Mexico, one of which the Drs. Gallant and Hawkins attended.
Mm-hmm.
Teva is also listed as a funder. They're not a sponsor level, but they are a funder of that as well.
But to be clear, that conference or that event was
Yes.
not, it included this particular drug, but also included other drugs as well.
That's true, Your Honor. It
Okay.
would. It would have. It was a broader conference on women's health, the one I'm thinking of specifically. But one of the express topics was HIV-infected women and the effect on their birth and treatments, these parties, defendants' drugs for those women with HIV.
It seems to me they're arguing that that conference would have to include a pitch about either staying with the name brand or going to the generic. It has to have, I think counsel said, be related to the particular claim.
The only reason they're sponsoring this conference, again, this was years ago now, right? And again, we had no evidentiary hearing and discovery's not begun yet. The only reason they're having this conference is to encourage the doctors to prescribe these drugs and switch to their drugs.
Can I ask about conspiracy?
Yes, Your Honor.
jurisdiction?
Yes, Your Honor.
I gotta say, in our world, we see a lot of conspiracy on the criminal side. It's a little concerning, quite frankly, how broad it is. And I have that sort of sense in this concept. Can you tell me the latest announcements on establishing what they describe as conspiracy jurisdiction, which is, I think, is a term used as well. And it goes directly to Teva, this idea that they're in this case because of this settlement.
I do not know offhand, because it's not a part of the issue presented, the latest speaking on conspiracy jurisdiction. What I do know is that lower New Mexico courts and other courts throughout the country have used it as a proper basis to assert a jurisdiction when a plausible conspiracy is alleged. And I'd say, as the defendants are very wont to point out, there's a case going on right now, in trial, mind you, against these defendants. And the trial started, I believe, Monday of this week, on that same conspiracy that we allege. So whatever the actual standard and state of conspiracy jurisdiction, which isn't within the confines of the question today, I'd suggest that we certainly make a plausible case that it exists, which we alleged and argued below in our briefing. And the very fact that these defendants are sitting in trial right now in a federal court in California on the same conspiracy jurisdiction shows that at least another jurist found there was sufficient evidence of a plausible conspiracy basis to assert conspiracy jurisdiction. There is, and I'm happy to answer more questions than anything particular, Your Honors, but just to sort of address some things I heard in no particular order from the defendants.
Should this court adopt stream of commerce? And is that contrary to Ford? And why is this like or not like strict liability found in products liability cases? Those are the big questions. I wouldn't bounce around. You need to go right to the heart of it.
I understand, and Your Honor is 2 steps ahead of me. That's where I was hoping to go. I think the short answer is yes, this court should follow stream of commerce theory as articulated in Sproul. It's been the law of the lower courts for quite some time now. They've had no difficulty applying it. They've consistently applied it.
Well, yeah, it's really not hard to apply stream of commerce because, I mean, you could be like an Etsy manufacturer making buttons and end up with nationwide jurisdiction under stream of commerce.
Well,
Etsy's a national, used by everybody in the country. I mean, that's I'm using the extreme here because,
Sure.
of course, courts haven't had a hard time applying it because you can drive a semi-truck through it. That doesn't, and just because Sproul said it doesn't mean we should say it. So I need to understand why Sproul, you think is, or the cases cited in Sproul are the current status of the law from SCOTUS.
Understood, Your Honor. And as the U.S. Supreme Court has said, and as this court in State XRL Martinez versus City of Las Vegas has said, has affirmatively cited, that the Supreme Court's decisions remain binding precedent until we see fit to consider them, regardless of whether subsequent quick cases have raised doubts about their continued vitality. Nothing I heard today, and nothing I saw in the voluminous briefing through 3 levels of court, say that worldwide Volkswagen was ever explicitly overturned by the U.S. Supreme Court. Are there fractured plurality decisions after worldwide Volkswagen? Yes. But not in any of those cases. Ford, BMS, Walden, Dunlap, any of the jurisdiction cases going back to 1980 or so when it was issued, none of them said worldwide Volkswagen is overruled. And under this court's longstanding jurisprudence, this court will defer to the U.S. Supreme Court to make a decision as to when to say its precedents should be overturned. So we would suggest, Your Honors, that given that worldwide Volkswagen, as other states and federal courts have said, this is not going out on a limb. We cite a number of other state Supreme Court decisions, Idaho, Iowa, Fifth Circuit, Seventh Circuit, other circuits, other state Supreme Courts, Colorado, other states have recognized, and other federal courts have recognized that the United States Supreme Court has never said worldwide Volkswagen stream of commerce is done.
But counsel, the world has changed a lot since worldwide Volkswagen was decided 40-some years ago. People weren't selling things on the internet. There weren't websites. It was a lot more difficult to enter the stream of commerce in 1980. Why should we continue to follow that direction when all of a sudden all of our markets have become global, they're opened up, they're really much easier for the average person to use rather than a huge corporation?
I think, number one, and even International Shoe in 1945 said that specific jurisdiction is not going to turn on physical presence anymore, and that was quite a long time ago. And I'd say that given that what we're dealing here is the still in effect stream of commerce, one of the issues, and you hear foreseeability a lot and mere foreseeability, I think it's important to remember, Justice Vargas, that in worldwide Volkswagen and what defendants, I think, are referring to when they say foreseeability, they're using it in a very general, generic sense. The issue in worldwide Volkswagen for foreseeability where it was too far was German company sold to the tri-state New York, New Jersey area, Connecticut area, a car, which went to a car dealer in New York. They sold it to someone who lives in New York. It was not foreseeable because the stream of commerce is over at that point, right? It went all the way to the end user, right? Manufacturer to end user. It wasn't foreseeable that those New York residents might drive the car on their way to Arizona and might get into an accident in Oklahoma. Here, the stream of commerce is still happening. The defendants seem to suggest, oh, well, we gave it to a third-party distributor. That's still distribution in the stream of commerce, right? It is still going from the manufacturers, these defendants, to a distributor or wholesaler, to a retail pharmacy here in New Mexico, and then to the final end user. That's the stream of commerce. And when you're in the foreseeability question there is slightly different. When you're injecting a product into the stream of commerce, it's foreseeable what the natural stream of commerce is. And there's really no question here, given that they're the only ones who sell this product. They're using wholesalers that they know will service New Mexico. Their website says go to these pharmacies or get this copay assistance if you're in New Mexico for our drugs. In that sense, the foreseeability, I believe, is sufficient versus when you say the mere fortuity or isolated instance of the stream of commerce ended, the product was sold to an end user. Lord knows what the person might do with it.
Maybe I'm getting more at the reasonableness, fair play, substantial justice from when I ask my question. Like I said, the world has changed, and now, as Justice Bacon mentioned, you could have a stay-at-home mom in Vermont manufacturing buttons, sending them out into the world, who ends up being sued in New Mexico because someone was injured by that button. How is that inappropriate? Why should we keep a stream of commerce analysis when it seems like there are issues of fair play that are concerning?
There's 5 factors usually looked at by this court in the U.S. Supreme Court for the traditional notions of fairness to exercise jurisdiction. Plaintiff's interest, the forum state's interest, interest in an efficient judicial system, the public policy, and the burden on defendants.
And who has the burden of proof on those 5 factors?
At this point, I would probably have to concede the burden is on us as the party resisting the personal jurisdiction motion, but I believe it would be under the standard that inferences would have to be made in our favor under the cases I said.
Even though the burden on the defendant is of primary importance in the 5 factors?
I would respectfully disagree. The burden is of primary importance. I also believe that
That's a quote from Bristol Myers.
There's also no evidence in this case of any burden in their carefully worded in-house lawyer affidavits. They talk about where they distribute the chattel of the property.
Well, the other case is being tried right now.
Mm-hmm.
Inconsistent verdicts is a burden on the defendant.
The federal court system has already said, the federal district court in New Mexico already said the federal court system does not have jurisdiction over New Mexico's claim, or the state's claims in this action. They removed it. They said jurisdiction in the federal system did not exist. We already have the federal court saying that for efficiency's sake, this should not be here. This case, these claims brought by the state belong in New Mexico. In terms of what they're saying is efficient, and it's in California. I'm not sure how it's more efficient than Teva. Teva says it's a New Jersey corporation with a principal place of business incorporated in Delaware. I'm not sure how California is not a burden. If they did not contest jurisdiction in California, that's one thing. It's New Mexico citizens' rights. It's New Mexico, the state attorney general's right to bring claims on behalf of New Mexico consumers under New Mexico law that the New Mexico legislature said specifically reaches interstate commerce in New Mexico courts, especially when the federal court has already said, no, we don't have jurisdiction over this. This should remain in New Mexico.
Okay, so you have the burden of proof on the 5 factors.
Yes.
So we're going to talk about the 5 factors.
Absolutely. I think it goes without saying that plaintiff's interest here is in the state of New Mexico. The injury occurred here. It's the state of New Mexico enforcing a New Mexico statutes for antitrust and unfair practices on behalf of New Mexico consumers who were prescribed drugs purchased in New Mexico by New Mexico doctors. I don't think there's really any question that plaintiff's interest here is very high in New Mexico, that there's really no state that would have a higher interest, in fact, in seeing these claims. The federal court system already said we have no interest, that it should be in New Mexico. And I'm hard pressed to see how the state where the quote first sale of the drugs, where they say, well, we transfer title in California, or where we design the drug, or we patented the drug. Those are the very things that the Ford court and Justice Alito in its concurring opinion said, that doesn't matter. That Ford would send the plaintiffs in those cases packing to where the product was first sold, designed, or invented. And that's exactly what they're trying to do, what the Supreme Court expressly rejected in Ford. The forum state's interest, obvious, I think goes without saying almost, and we cite this court's precedent and other precedents that the state has a very high, if not paramount interest in protecting its own citizens for its own disbursements
But you
for these
wouldn't
products.
be without a claim. I mean, you could join the California lawsuit. It's not as though I understand the argument and I appreciate the argument about it being in New Mexico, but you wouldn't completely be without the opportunity to seek a remedy, I assume.
Well, I don't think the issue is the remedy. I think it's
It's where it's held.
It's
right?
the power. It's the power of which courts to hear the claim, and New Mexico courts have the power to hear these claims under New Mexico law for New Mexico payments. Federal court has already said that we don't have the jurisdiction to hear these claims. And in terms of public policy, the other factor as well, I think it touches on a lot of the same factors I already discussed in terms of the plaintiff's interest, the state's interest, the forum's interests, the fact that the federal court has already said that the cases belong here in New Mexico state court. as well as the legislature in their enactment of the Unfair Trade Practices Act and the Antitrust Act, they specifically say that the purpose of these is to protect New Mexico and New Mexico citizens for effects on interstate commerce. They already made the declaration, policy statement, that these laws, that just because something deals with out-of-state commerce does not mean they're beyond the reach. And as the Supreme Court of New Mexico said, this court said in United Nuclear, if the fact that the commerce at issue involved the national market were enough to render state law invalid, the state's power to regulate anti-competitive practices would be effectively destroyed. And finally, in terms of defendant's burden, the fifth factor, Your Honors, clearly they haven't come forth with any evidence suggesting burden other than arguments in their brief. Their affidavits are devoid of anything about burden. Teva's been litigating for years. I believe they just settled a couple months ago their opioids trial against the state attorney general's office as well. They've litigated here before. There's really no question
Did
that's
the
more burdensome.
trial court even consider the 5 factors? Was that part of the trial court's analysis when the ruling came down on jurisdiction?
I think it was, if not explicitly and certainly implicitly. We certainly made it explicit.
I don't see it.
Mhm.
I don't see any discussion of in the order or the oral ruling that the court considered the reasonableness prong, using that as shorthand.
I'll confess, Your Honor, I don't have it in front of me, the transcript. I'd have to look at it. All I can say is we did, in our briefing, our main briefing and an oral argument, certainly did address
Yeah,
it.
it would.
But
But
yes.
I'm not, and if the trial court didn't address that,
Mhm.
where does that leave us?
I think this court could still dismiss the petition and affirm the ruling. It would still be a question, a legal question that this court could reach. But I think, in fairness, if the court were inclined, it certainly could remand to the district court level for those specific findings. But I think it would be within the purview of Your Honors to make that legal ruling now, if it's believed not to be sufficiently expressed in the
Can
letter.
I ask you one more question about
Yes, Justice.
discovery? Did the state ask for any discovery on the jurisdiction issue before the motion to dismiss was heard?
We did. In our opposition, we put in the opposition specific may I answer?
Yes.
We specifically put numerically the exact subject matters that we want in terms of their contacts with their distributors, their knowledge of where the drugs are going, the rebates they're getting from the pharmacies and their distributors back on the sales of their drugs at super competitive prices in New Mexico. We enunciated it all in an oral argument. I certainly did note it again, and the trial court did not see fit to reach that issue.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honors, the first point I want to make with respect to Volkswagen. Counsel says Volkswagen has never been overturned. That's because the holding in Volkswagen was that there was no personal jurisdiction. The language that some courts, and at this point not a single federal circuit court since BMS and Ford has adopted this pure stream of commerce, but the language that essentially became stream of commerce was simply dicta from Volkswagen. So it doesn't need to be reversed. And in fact, even in Asahi and in McIntyre, where pluralities of the court adopted a stream of commerce plus, they never saw fit to say, oh, we're reversing Volkswagen, because it didn't need to be reversed because it was never a stream of commerce holding. With respect to some of the other questions that came up, you're right. The Attorney General could bring a lawsuit in California. He has brought lawsuits against Facebook and Google in states appropriate for jurisdiction. In the current California case, where we're picking a jury a week from today, the University of New Mexico and many other New Mexico entities are actually plaintiffs seeking millions of dollars of damages. So there's no question of fairness here. What due process focuses on is, at the end of the day, as the Supreme Court has said, fairness to the defendant and specific jurisdiction as opposed to general jurisdiction has to follow the test that BMS and Ford has established, which this court in Chavez acknowledged, and which lower courts in New Mexico are already following now. Most recently, the Grano court in mid-April in just deciding that there was no personal jurisdiction, applying the appropriate test. I want to address a couple of the specific factual points. Justice Thompson, you raised a question about the payment assistance program. I want to just quote from the Supreme Court's decision in Tercero. The existence of personal jurisdiction may not be established by events which have occurred after the acts which give rise to the plaintiff's claims. They cite a LinkedIn posting for a job offer that's not even in HIV drugs, it's hepatitis drugs, and it's 7 months after they filed their complaint.
What about the payment program, the payment reimbursement?
The payment reimbursement is simply a national program, and the 10th Circuit in the Old Country case, the 3rd Circuit in the Schuker case, the Tennessee Supreme Court in a tobacco case made clear that national programs like this, unless they are specifically targeting a particular state, are not an indication of the type of availment that gives rise to personal jurisdiction. And that's not even getting to the related
It's your representation today that Gilead did not avail consumers to that reimbursement in New Mexico.
That is correct, Your Honor. All Gilead did was have a website that said,
No. Did a consumer that used the drug avail themselves to that reimbursement?
a consumer may well have, but the Supreme Court made very clear in Walden that the plaintiff's conduct cannot confer jurisdiction on the defendant. It has to be the defendant's conduct. So if the defendant is having a program in New Mexico, targeted New Mexico, that would all for sure be a connoting jurisdiction, but not if the plaintiff simply avails itself. Two other very brief points. They bring up this Find a Pharmacy website. This court in Hale versus Basin made very clear that something that is raised for the first time in a reply brief at the Supreme Court will not be addressed. That's Hale versus Basin, this court's decision. They did not even mention the Find a Pharmacy program until their reply brief. And in any event, all that is, again, is a nationwide locator.
What about the clinical trials and the doctors Gallant and Hawkins that he's referring to as possible contacts?
Sure.
I want to make sure,
Yeah.
like there's a bunch of drugs being talked about. I want to focus on
the clinical trial was purposeful availment with respect to conducting a clinical trial. If there had been a cause of action relating to the clinical trial, a malpractice case or a fraud in the inducement, we wouldn't be here arguing what we're arguing today. Hiring two doctors who used to be in New Mexico to work in California, that's the opposite of the kind of contact they would need. They would need evidence that those doctors who are sitting in California are actually going into New Mexico to advertise or promote. And finally, they mentioned these symposia. This was an international conference that chose to have its conference 1 year in New Mexico. And we were one of many sponsors targeted at women's health. Again, not targeting the allegations, as you point out, Justice Thompson, of trying to get consumers to switch.
Small.
Sure.
Little.
Give you a small answer.
Just on the motion to dismiss, are we
Yes.
asking a lot? Well, let me ask it this way. Should the trial court have had particular findings with regard, let's say, to the 5 factors of the motion to dismiss stage? We're asking a lot at that stage, at least under how we operate here. I mean, they're looking at the pleading and it's well pled.
I think, well, it was arguably well pled until we put in affidavits. And this court said at that point, the burden flips. The real problem is the trial judge didn't use the proper standard. It didn't do the 5 factors, but it didn't even apply the purposeful availment and related to factors. So the trial judge essentially made no factual findings of any relevance to this case. I think this court needs to establish what New Mexico believes the Supreme Court has established as the standard for personal jurisdiction. Either look at the record de novo and say there is none, or potentially remand with instructions to follow the appropriate test.
Thank you. Thank you, counsel, for your argument today. The case is deemed submitted as of
Thank you.
Attend the court, please.